Hello, everyone, and welcome back to the Rebuttal Podcast, where we break down case law, calamity, and of course, chaos in the legal field. I am Reb Maisel. I am once again your host, and today we have laughs. God bless. We have laughs, we have giggles, we have the strange, we have the crazy, and obviously, the brand here at Rebuttal is I try very hard, but honestly not that hard at all, to bring you the cases in the legal field that don't get 7-part docuseries on Netflix, right? Like the Ted Bundys do, okay? Like the John Benet Ramsey cases do. Not because those cases don't totally deserve lip service, but after the 85th time that I could probably hear those things spoken about in a million different ways on every podcast, etc. There are so many other cases in the law that are so much more interesting and actually let you laugh, right? Because obviously murder cases or cases in which children are victimized aren't really the best to be giggling and laughing at and monetizing. That's why, a lot of true crime content is inherently unethical. But here, you listening to this episode will not make you feel bad or guilty or have a sick, nauseous feeling in your stomach. Today, we are talking about the case of Miles versus City Council of Augusta, Georgia, a case from 1982. Now, why would we care so much still to this day about a case that is over 40 years past, right? It's in the past. What could possibly have withstood the test of time when it comes to legal opinions, when it even comes to some giggles and laughs? I mourn every day the loss of great jokes and humor and footnotes and obscene, insane fact sets in cases that were just not heavily reported on from years and years and years ago, and all of the people involved passed away or just forgot about it themselves, probably lawyers who have a huge caseload, and now they're lost to time, right? I feel like I am a historian, an important one. Maybe I should be paid by the federal government. Maybe I should ask our administration currently right now if they have some dollars to spare. I feel like that would go over well, but whomst am I? This case has really never aged. Why? Well, because the facts are fucking crazy. Okay, the facts are fucking crazy. And the facts involve Blackie the Talking Cat. Let's begin. The plaintiffs, Carl and Elaine Mills, were an unemployed married couple who owned Blackie, a cat who could allegedly speak English. The plaintiffs were entrepreneurs in the true American mold, making their entire living marketing Blackie's unique vocal abilities to the public. Although the closest Blackie ever came to making the big time was a $500 appearance on That's Incredible in 1980, he generated steady income for Carl and Elaine by talking to strangers on the street in return for contributions. After receiving complaints, however, the Augusta Police Department warned Carl and Elaine that they needed to obtain a business license to continue peddling Blackie's talents on the streets of Augusta, Georgia. Plaintiffs sued the city, alleging the occupational license tax was unconstitutional. Obviously, this set of facts is bizarre, interesting, unique, definitely going to be turning some heads. And thank God I don't have to do anything to make this funny, because both of the opinions, the court opinions that this case passed through really do the damn job. Shout out to my 1980s federal judges who held it the fuck down in the comedy, humor, giggle department. Appreciate you. And when I say comedy, humor, giggle, I mean they were committing to every pun in the fucking world and were also sarcastic, ironic, dry as fuck, which I love. Who does that sound like? Love it. Through the course of the case, the plaintiffs and the defendant, the City Council of Augusta, Georgia, filed cross motions for summary judgment, meaning that they both thought that on the merits, on the facts, and the law, they should win. The legal issues in this case didn't have to deal with whether we agree and decide and hold as a rule of law that a talking cat existed. The judges in this case pretty much say, yeah, he can probably talk, because it doesn't really matter. And also, how fun is it to say in a court opinion, sure, why not, right? The legal issues in this case are whether an ordinance requiring a business license in Augusta, Georgia was too vague and too overbroad to actually capture the talking cat model on the street soliciting donations, and whether that ordinance was a violation of the cat's free speech rights by limiting its ability to speak unless it paid via the ordinance for that license. The third legal issue, why it outstood and outlasted the test of time, is whether a judge's ex parte communication with a talking black cat named Blackie is a violation of the rules, which hold that in order to rule on a motion for summary judgment, the judge must only consider the facts before it in the record and not any that are outside the record. And the judge had apparently encountered and paid for the black cat's services in speaking English prior to this case and not as part of the record. Welcome to the legal field. This is not even that weird for us, I swear to God. But let's start from the beginning. The partnership between Blackie the cat and the Mileses began somewhat auspiciously in a South Carolina guest house. According to the deposition of Carl Miles, the husband, and this husband-wife talking cat trio business partnership, he said that he was psychic and somehow knew this cat had big potential. Quote, well, a girl come around with a box of kittens and she asked us, did we want one? I said no, that we did not want one. As I was walking away from the box of kittens, a voice spoke to me and said, take the black kitten. I took the black kitten, knowing nothing else unusual or nothing else strange about the black kitten. When Blackie was about 5 months old, I had him on my lap, playing with him, talking to him, saying, I love you. The voice spoke to me saying, the cat is trying to talk to you. To me, the voice was the voice of God, end quote. Listen, no tea, no shade. I don't judge. I believe it. Who am I? Whomst are we to doubt the efficacy of someone's very strange divine attachment and communication messages being told to them in relation to a cat? I'm sorry. Go to Egypt. Google Egypt. Did you go to that course when you were in elementary school history? Okay, you turn the page. What do you see? Massive statues, shrines, entire religions, cats, around cats, related to cats, worshiping cats. So really, if you want to make fun of Carl here, my boy Carl Miles in the 80s in Augusta, Georgia, you're going to have to take it up with the Egyptians in 20,000 BC. Don't even think that's the right year, but we're going to work with it. Is it worth Googling? Fuck. Ancient Egyptians. 2000 BC. That's what I'm going with. Ish. All right. And we can't talk to them. And I don't want to talk to them because everybody who opened up King Tut's tomb died or had something horrible happen to them. So white people are so annoying. They just be going in places they don't need to go to and they get cursed and then wonder why they're cursed. And now it's like the modern version of that is like, let's go cave diving. The fuck are we doing? Look, I heard about this crevice that's the size of a nutsack that apparently one guy was able to squeeze his body into, reshape his bones to be able to go through it. We should try that. I don't need to be diagnosed claustrophobic to have a survival instinct, to think this is uncomfortable, to think this doesn't feel like something that someone who would like to live for longer than the next 5 minutes would do or enjoy doing. I understand an adrenaline rush, jumping out of a plane, cliff jumping, cliff diving, even like the rock climbing stuff. Like I understand that. Shark cage diving. None of that is to me, even if I don't want to do it or whatever, which like some of those things I kind of down, like I understand like you're getting a rush and like cheating death, but also, you know, you train for it to be able to survive it. Like I understand why those things are enticing for sure. And then when people pass away, like that is still tragic. It's like, okay, yeah, like they're doing what they loved. To cave dive through those dumbass crevices, okay? Like the famous story of the Nutter Butter cave diving guy, all right, who I don't know why it's called the Nutter Butter. I think it's like this crevice was in the shape of a Nutter Butter. Beyond me, okay? Nut putty nut. I don't know, okay? It's something like that. He had like a wife and an infant baby at home. And he was out here gallivanting and got stuff. If you look it up, like just look it up now, okay? You'll see the diagram of what his body was stuck in and how long he was stuck upside down. He basically died because like all the blood it just like rushed to his body. Like he like basically asphyxiated on his own situation. But it was like the slowest death of all time. All these people tried to get him out, but there was no way to get him out. He was just wedged down there. Like you see photos, it's like his one little foot like sticking out. His body's still there. They can't retrieve it. I think. There are so many stories like this. What are we doing? And I know people will be like, it's not just white people. I fear we just have this innate natural selection that should have killed us off already. Curiosity. Like curiosity didn't kill the cat. It should have killed a lot more white people, to be fucking for real. Unfortunately, for every indigenous society, Native Americans, South American societies, like I wish so badly that the whole diseases shit would have been flipped, right? Like we were like, we're so curious, like why don't we like go colonize people and, you know, force them to convert to Christianity and commit all these horrible, heinous crimes against them simply for just being indigenous people who were here on this land fucking first. I wish that we had all gotten the fucking smallpox and diseases because of that, right? It's like fuck around, find out. Instead of the opposite of us, like giving smallpox blankets to Native American communities and then wiping them out. I really fear and feel like that would have helped a lot with respect to weeding out some people who like, why are you microdosing a very horrible death? The worst death I can ever imagine. I don't know. I don't even know how I got on this topic, but my point basically was I'm not going to judge somebody who claims that they're psychic if all that comes out of it is a fucking talking cat that can tell me that they love me. I'm obsessed. Here's $20. Back to the show. Mr. Miles set out to fulfill his divination by developing a rigorous course of speech therapy. Quote, I would tape the sounds the cat would make, the voice sounds he would make when he was trying to talk to me, and I would play those sounds back to him 3 and 4 hours a day. And I would let him watch my lips, and he just got to where he could do it. We are putting Blackie the Talking Cat through rigorous linguistic schooling. He has a dialect coach, the likes of which a lot of these big Hollywood actors trying to do a Southern accent can't afford, apparently. More power to Carl. Blackie's rigorous and forced studies soon paid off. According to Mr. Miles, quote, he was talking when he was 6 months old, but I could not prove it then. It was where I could understand him, but you can't understand him. The regular public couldn't understand him. It took me altogether 1.5 years before I had him talking real plain where you could understand him. In no time at all, Blackie's talents were, of course, taken to the marketplace, and the rest is history. Blackie catapulted into public prominence when he spoke for a fee on radio and on television shows such as That's Incredible. Mr. and Mrs. Miles capitalized on Blackie's linguistic skills through agreements with agents in South Carolina, North Carolina, and Georgia. The public's affection for Blackie was the catalyst for his success, and Blackie loved his fans, apparently. Sadly, Blackie's cataclysmic rise to fame crested and began to subside. The Miles family moved temporarily to Augusta, Georgia, receiving contributions that Augusta passersby paid to hear Blackie talk. Not only would passersby pay to hear Blackie talk, but it is undisputed in the record and evidence and by witness testimony that Blackie would become catatonic and refuse to speak whenever his audience neglected to make a monetary contribution. What a business cat. What a guy, right? What a diva, I would say. In honestly a very positive light. Get your bag. Do nothing for free. This is not unpaid labor. These hours are billable. Baby, this shit is not free. Obsessed. Blackie's abilities on the streets of Augusta included allegedly being able to speak several words and phrases of the English language. Therefore, from May 15th to June 22nd, 1981, Carl and Elaine Miles had accepted contributions from pedestrians in the downtown Augusta area who wanted to hear the cat speak. People would stop the plaintiffs who strolled the streets with the cat. Upon being stopped, plaintiffs would ask for a contribution. There is, however, evidence of the plaintiffs soliciting an off-duty policeman for money in exchange for a performance, but plaintiffs dispute this allegation. So essentially, they are claiming that people would stop them and come up to them and ask for their service instead of them basically following people around and saying, pay us to hear our cat talk. We swear he can talk, right? And as we already know, Blackie was not doing it unless it was for $1. You weren't even going to get a taste unless he heard the little plink of the coin in the pan, baby. All right. Nothing wrong with that. But unfortunately, with respect to soliciting laws and business licenses, may be something wrong with that, right? In Augusta at this time in 1982 or 81. In 81, all right? But it is undisputed that plaintiffs would ask for and live off of the contributions received for Blackie's orations. This was their entire income. This cat was holding it the fuck down, okay? He was child labor. Honest to God. I mean, who knows how old he was? He started doing this at 6 months, right? Claiming to have started talking, but he was studying before then, just a few weeks old. I mean, this must be how these child actors feel, right? Fresh out the womb, being propped up for a Gerber ad, except they have to actually talk in full sentences. They got a script. That cat should have had an agent. That's what should have happened, but neither here nor there. Several complaints, unfortunately, were received by the Augusta Police Department regarding the plaintiffs' solicitations. Plaintiffs were then warned by the police not to solicit unless they first obtained a business license. Through their exploit of his talents, Blackie the Talking Cat had provided his owners with at least the minimal necessities of life. Plaintiff Carl Miles had entered into several contracts with talent agents in Georgia, South Carolina, and North Carolina. Okay, then I was wrong. He was already agented up. He was already signed, baby. These agents have paid, at least in part, the Miles's living expenses over a period of time. The evidence does not clearly show that this support was provided during the relevant period of May 15th to June 22nd, 1981, because as we know, Blackie the Talking Cat did indeed, his popularity fell off. Okay, he fell off a bit. So he needed to hit the streets, but that's okay. It does, however, permit the inference that prior to the plaintiff's arrival in Augusta, they intended to commercially exploit Blackie's talking abilities. I love the law. I really do. The judge adds a footnote here and says, quote unquote, that a talking cat could generate interest and income is not surprising. Man's fascination with the domestic feline is perennial. People of Western cultures usually fall into two categories. Generally, they are ailurophiles or ailurophobes. Ailurophobes are the ones who have an irrational fear of cats. Ailurophiles are the ones who you can guess are the opposite of those, okay? Cats are ubiquitous in the literature, lore, and fiber of our society and language. The ruthless Garfield commands the comic strips. The Cat in the Hat exasperates even Dr. Seuss. And who hasn't heard of Heathcliff, Felix, or Sylvester? Historically, calico cats have eaten gingham dogs. We are taught that a cat can look at a king, and at least one cat has been to London to see the Queen. The judge continues, quote, for hundreds, perhaps thousands of years, people have carried on conversations with cats. Most often, these are one-sided and range from cloying, mawkish nonsense to topics of science and the liberal arts. Apparently, Blackie's pride does not prevent him from making an occasional response to this great gush of human verbiage, much to the satisfaction and benefit of his owners. Apparently, some cats do talk. Others just grin. This is, I think, the first time in a federal court opinion that a judge has confirmed that a cat does indeed talk, can indeed talk, and does it with such great skill that they are being paid and supporting a family for it. Animal rights, I say. Feline acknowledgement. Their contributions to society, if you will. And that entire footnote was dead fucking serious, which I agree with. But let's get to the law. Right? What is the law here? The ordinance is the law. Under its charter, the city of Augusta is empowered to impose license taxes. Section 139 of the charter states, in pertinent part, the City Council of Augusta, by ordinance, may require any person, firm, or corporation to pay a license tax upon any occupation, trade, or business followed or carried on within the corporate limits of the city of Augusta. Pursuant to this enabling provision, the City Council enacted Ordinance number 5006, the 1981/1982 Business License Ordinance. The ordinance exhaustively lists the trades, businesses, and occupations subject to the ordinance and the amount of tax to be paid. Although the ordinance does not provide for the license of a talking cat, because as the judge notes, probably not something they contemplated here. Didn't know that a cat could go the distance. Section 2 of the ordinance does require any, quote, agent or agency not specifically mentioned to pay a $50 tax. So they're like, anyone that we didn't include, there you fucking go. Okay? Pay the fuck up. Carl and Elaine Miles paid the $50 after the police basically threatened to jail them, and they immediately filed a lawsuit for not only the, I guess, overturning or withdrawal of the application of the ordinance to them because it doesn't apply to talking cats and it's too broad and they should get their money back, but they also want $500,000 from the city council for just general damages, pain and suffering, distress, all of that. Okay, so just like FYI. What's $500,000 in 1981? Just give you an idea. Carl and Elaine Miles, in their lawsuit, attack the ordinance as being unconstitutionally vague and overbroad in violation of the due process clauses of the 14th Amendment to the United States Constitution and the Georgia Constitution. They contend they are not required to obtain a license and that requiring them to do so before they may solicit on the streets with Blackie the Talking Cat and sole provider violates their First Amendment rights of speech and association, as well as the right to equal protection secured by the 14th Amendment. Mind you, their First Amendment rights to speech, they were suing on behalf of Blackie's rights to his speech, to the extent that he speaks. Spoiler here, okay? I'm not going to hide the ball from y'all. They did find in this case that cats do not have a First Amendment right to speech. I know, troublesome for sure. This case is still cited for that fucking principle to this day because there are so many disputes, if you can imagine, in relation to custody disputes and battles that deal with the custody of pets, okay? And like whether or not one X is allowing the dog to bark with reckless abandon. You know how people can get, right? Weird and how they can get. And yeah, the court cites this case and goes, so yeah, they don't have a First Amendment right to speech. I'm sorry. I'm so sorry. Not giving you my opinion on that. Okay, it's just a fact. All right. The judge's analysis, however, concludes that the ordinance does not tread upon the plaintiff's constitutional rights. The power of the city council to levy an occupation tax is unquestionable. The city charter authorizes the very ordinance passed by the council. The taxing power, as embodied in a municipality's charter, is well recognized as a means for raising revenue. The taxing power is a power of the state that is delegated to the municipality it creates. License fees or occupation taxes placed upon trades and occupations are a legitimate method of taxation, even though such a tax may render a business unprofitable. Moreover, the amount of tax levied against different trades and businesses need not be uniform or the result of the application of a precise scientific formula. Thus, it is clear that the city council is authorized to require the procurement of business licenses. The ordinance is not one designed to regulate speech or association, but merely to raise revenue. The ordinance does not subject anyone's speech or associational activity to any penalty unless committed within the context of one's occupation for which a tax has not been paid. The court then analyzes, in more of a boring analysis, I'll spare you from your welcome, essentially that the ordinance is not too vague and it's not too broad by kind of including the plaintiffs and Blackie the Talking Cat's dealings, okay, way of making money in this catch-all provision of, you know, any other agents or agencies that we haven't specified, like pay the $50, okay? The plaintiffs are arguing, well, that's too broad. Like you should have a specific thing that we need to fall under. And yes, it's a fair argument. Like it's not a crazy thing to argue that statutes need to be specific. I mean, you've seen in the last 2 episodes, I have spoken about absolutely a lot of criminal, especially statutes. If they are not specific, they are not fucking specific. Okay, you can't have a catch-all. But this is a tax situation. It's a city ordinance in relation to taxes. And there is the balance that the court and the laws have to strike in basically predicting and having the reasonable foreseeability to say, hey, yeah, there's literally no fucking chance that a common sense tax ordinance, a business tax ordinance for the purpose of generating revenue for a city council could ever possibly list every single possible description of every business and occupation. We can't have that type of loophole. And this is what they say. At the outset, it is noted an exhaustive list of businesses, occupations, and trades subject to taxation is indeed contained in the ordinance, okay? The only catch-all provision is at the very end. Equally important to note, however, is the practical impossibility of specifying with particularity each and every occupation, trade, or business that would conceivably come within the ambit of the ordinance. Plaintiffs cannot reasonably argue that before the defendant can require a business license for a talking cat, it must specifically provide for such an occupation in its ordinance, because how the fuck would they know that would happen? The self-evident thrust of the ordinance is to tax occupations, businesses, and trades that derive income from the practice of that occupation, business, and trade in the marketplace. In other words, where a person, firm, or corporation engages in regular commercial activity with the public for the purpose of gaining economic benefits or advantages, that person, firm, or corporation is subject to the ordinance. Given the exhaustive detailing of the wide variety of occupations and businesses covered, it requires no great leap in logic to hold that a catch-all category is intended for those unique, extraordinary occupations such as plaintiff's talking cat used to obtain economic benefits. Plaintiff's contention that they are not required to obtain a license carries the implication that they are not engaged in an occupation. In their brief, plaintiffs cite several definitions of the term occupation and business, but the general importance of these definitions is that one is engaged in an occupation or business when that work or activity occupies one's time or attention on a regular basis for profit or support. Inasmuch as the ordinance does not define occupation or business, the common definition cited above applies. The plaintiff's activity, including Blackie the Cat's, regardless of its peculiarity, falls within this definition. Carl Miles, in his deposition of April 23rd, 1982, stated that prior to June 22nd, 1981, he would ask for a contribution when people asked to hear his cat talk. From May 15th, 1981 to June 22nd, he received enough contributions, usually 25 cents or 50 cents each, to pay his weekly rent of $35 and purchase other necessities, except for a 2-week period in which he used money from his savings. The phrase, to pay his weekly rent of $35, I'm going to let that sit. I'm going to let that sit for a second. It hurts. It hurts the same way that regular exercise hurts. Anything really worthwhile focusing on can hurt, right? That fucking hurts. That hurts. But you know what it does keep me? Pissed the fuck off. Because what was the minimum wage back then? And what is it now? Let's see. The federal minimum wage in the United States was $3.35 per hour. The minimum wage today is $7.25. But if we account for inflation, $3.35 in 1981 is worth about $10.96 today when adjusted for inflation. So when adjusted for inflation, that minimum wage was the equivalent of $11 an hour. Our minimum wage today is $7.25. It has not changed in several years. That hurts. Let's continue. Carl Miles and his wife were otherwise unemployed with no other income. Plaintiffs would walk with the cat in the vicinity of Broad and Green Streets, major avenues of motorized and pedestrian traffic, for several hours a day. Thus, they were regularly engaged in a pursuit yielding income, however small. The plaintiff's commercial interest in Blackie is well established. It is undisputed that before they moved to Augusta and after the business license was obtained, Carl Miles entered into several agreements with agents from 3 different states, and he appeared on television and radio. Blackie, not Carl, Blackie appeared. Although that activity occurred prior to the plaintiff's move to Augusta, it is relevant to show the interest that the plaintiffs had in exploiting Blackie on a commercial basis. You can't say this isn't a business, baby. You cannot claim that this wasn't your sole and only and legitimate and primary purpose, all right? And it falls under the definition of a business. I, of course, would totally support having them do this for free, but also, like, I understand, okay, $35 a week is your rent and they're making you pay a $50 business license, like, tax, like, totally get it, but, like, isn't that like that's like a one-time, like, probably yearly thing, right? Pay it and you're done. Make that up, right? Have Blackie throw in some overtime hours on that timesheet. You know what I mean? Drop that card in. And look, the animal abuse people are going to yell at me. I am also an animal abuse person, right? That's horrifying and horrible. And I fight for them, whatever. These are jokes, all right? This cat is unfortunately long expired. RIP. But I do think that they thought they were going to loophole the house. And I've featured other cases where they have loopholed the house and fucking won big. So this is just an example of, listen, like, shooter's going to shoot. Shoot or shoot. And I appreciate that they shot this. I appreciate that they did, okay? The interest coupled with the near daily receipt of contributions requested by the plaintiffs for performances by the cat brings them well within the definition of occupation. Furthermore, the question of obtaining a business license was not new to Carl Miles. He had on previous occasions in Charlotte and Columbia inquired as to the necessity of a license. He therefore viewed his exploitation of the cat as a business activity for which a license might be required. The fact that those cities did not require a license does not alter the nature of his activity or prevent the city of Augusta from requiring one. Since they did not hold themselves out as a charity, the plaintiffs cannot persuasively argue that their activity did not require a license. The ordinance is thus not impermissibly vague or a violation of their constitutional rights. Do you see how even when the facts and the circumstances are seemingly very outlandish, are just seemingly so redonkulous that you would think the answer is so easy, duh, obviously. No, baby. Okay. We as lawyers and judges in the law, we do the damn work. We do our due diligence, okay, to make sure that every freak fucking flag flown in our court is given the lip service it deserves. And this was some lawyering, baby. I love this opinion. The judge ate down. Like, look, not only do we, we're not just going to say it's a fucking business and throw you out. We're going to use context. We're going to use, everything that we can in terms of what's in the record to really, really establish and support and show that, yes, like not only does the actual thing that you did, the actual conduct that is undisputed that you did on the streets of Augusta fall under the definition of a business occupation that would fall under or be subject to this tax, but also we're going to look at your fucking conduct. Did you treat it as such, right? Did you treat this shit as a fucking business, as a income, gathering situation? Of course you did. Okay, of course you did. C, XYZ, and AAA. To prevail, plaintiffs must show that their conduct is constitutionally protected, aka exempt from taxation. Plaintiffs cite no authority that holds commercial solicitation exempt from taxation. Plaintiffs' conduct is not barred by the ordinance so long as they do not seek out contributions. Once their activity becomes a commercial venture, it falls within the legitimate sweep of the ordinance. Also, criminal activity, the criminal activity, is not the plaintiff's solicitation of money for Blackie's performances, but doing so without a license. So the court's saying, listen, like you can do all of that tomfoolery all you want. Like we're not going to yell at you about the solicitation necessarily, but like just you need to have a license. Like, okay. Plaintiffs therefore cannot contend that the ordinance impermissibly infringes upon their right to association since this right does not extend to commercial ventures. Accordingly, this license ordinance stands and it applies to them. Therefore, the district court judge granted the city council's motion for summary judgment and denied the plaintiff's motion for summary judgment. Okay. Our husband and wife and Blackie the Talking Cats. RIP. All right. So that means that the case is over and the W goes to the city council. Yay forever. But I will note here, okay, and the judge also notes that, as I said before, in the context of motions for summary judgment, the only things that the judge is allowed to consider. It's very, very rulesy. It's very important. Okay. Like you cannot go outside the record. All right. When you are a judge ruling on a motion for summary judgment, the only things that it can consider are the facts in the record, the law, the parties, evidence and their attachments, their exhibits, like everything that's been presented, discovered, submitted. Okay. As evidence so far. You can't go outside the record. You can't consider other things. We're looking at these facts. These are the facts. Okay. In this tiny, like if you had to literally pick up a bucket and say the only things that we have to fucking look at to decide this case. It's like Clue. Beautiful. Okay. Or like those like murder mystery games where you open them up and they just give you a bunch of fucking, like pieces of evidence and they're super fun to like do with someone and then you open the envelope and try to figure out like who did it, based on all this evidence and the photos. Imagine a motion for summary judgment being just that. You can't like outside start talking to witnesses yourself again just because no one talked to this one. The lawyers didn't. Like you're a judge. Like you're not a fact finder. Okay. You're the fact judger, trier. Okay. You're like, all right, let me see what you got. This is all you got? All right. This is how I'm ruling. Okay. And that's it. That is for a motion for summary judgment. Okay. Specifically. Don't be like, always. It depends. But because that's so important, and also because I have schooled all of you on in relation to the YSL trial and case, okay? Because in addition to that, there is a very, very strict rule and prohibition, a bar on ex parte communications in a case, okay? These two rules, the motion for summary judgment rule that you can't consider any facts and the ex parte communication rule, you can't have any ex parte communications as a judge, they crossed paths, okay? They crossed paths here. And weirdly enough, even though, yes, the facts of this case are crazy, that was kind of the reason why I ended up figuring out that this case existed was that lawyers think it's so funny and silly, this ex parte communication thing, which you'll also find funny and silly, but like I think the entire thing is kind of a clown show. And I am sat in the front row with popcorn. So whatever. But the rule against ex parte communications is that a judge cannot have any communications with a party outside of the presence of the other parties and their counsel in the case, okay? You can't do that, right? You can't have ex parte communications with a witness outside with just the prosecution there with you in chambers and not the defense and not tell them about it. Like you can't do that, okay? That's an ex parte communication. It's just a big no-go for obvious fucking reasons, okay? Any communication that you have with the judge as an attorney when you're on the case, like you need to send it, CC, even emails, even letters. Like everyone needs to be included on it. Every single person in the case needs to be included on it. Okay? Those are the fucking rules. So with that rule in mind, and with the rule in mind that they're only allowed to consider the facts of the record, all right, and not especially their own personal experiences, this is the very important footnote that this very, I think, ethically sound district court judge in 1982 decided to throw in there in the very beginning of his opinion. Quote, in ruling on the motions for summary judgment, the court has considered only the evidence in the file. However, it should be disclosed that I have seen and heard a demonstration of Blackie's abilities. The point in time of the court's view was late summer, 1982, well after the events contended in this lawsuit. One afternoon, when crossing Green Street in an automobile, I spotted in the median a man accompanied by a cat and a woman. The black cat was draped over his left shoulder. Knowing the matter to be in litigation and suspecting the cat was Blackie, I thought twice before stopping, but stopping I did. Observing, however, that counsel for neither side was present and that any citizen on the street could have happened by chance upon this scene, I spoke, and the man with the cat eagerly responded to my greeting. I asked him if his cat could talk. He said he could, and if I would pull over on the side street, he would show me. I did, and he did. The cat was wearing a collar, 2 harnesses, and a leash. Held and stroked by the man, Blackie said, I love you, and I want my mama, in perfect English. The man then explained that the cat was the sole source of income for him and his wife, and requested a donation, which was then provided by me, the judge. I felt that my dollar was well spent. The cat was entertaining, as was its owner. Some questions occurred to me about the necessity for the multiple means of restraint for the cat, the 2 harnesses, and the way in which the man held the cat's paw when the cat was asked to talk, but neither here nor there. These are not matters before the court and are beyond the purview of a federal judge. I do not know if the man whom I saw with the cat was the plaintiff, Mr. Miles, but nevertheless, this sequence has not been considered as evidence or as an uncontroverted fact in this case. It is simply stated for the purpose of a disclosure to the parties of the chance contact between a judge, me, and a party to the case, Blackie the Talking Cat, Carl Miles, his owner, and his wife Elaine. So this is how Blackie the Talking Cat went into legal history as, to the best of our knowledge, the world's first officially licensed talking cat. Because again, the outcome of this case was that, yes, they paid the $50. Yes, they did. That cat was licensed to talk and did indeed talk to the judge in the case, which was in a court pleading and confirmed. But unfortunately, Blackie the Talking Cat failed to find the lasting fame and fortune he undoubtedly deserved. In 1989, Carl Miles developed cataracts and he stopped publicly exhibiting his prized feline, although Blackie was still happy to chat with visitors at the Miles home. After battling multiple health problems, Blackie passed away in 1992 at the age of 18. Miles told a reporter that just before the end, the cat looked up at him and said, "One last time, I love you." And that, my friends, is the case of Miles versus City Council of Augusta. My rebuttal for today's episode is, if you want to have your sole source of income come from a pet, an animal that you discover on the street somewhere, in a cardboard box, maybe in a litter, as Carl did, and you think maybe this is going to be my chance to really never have to work except for getting all my money from what this cat can do, remember to listen for any universal God-like divine signs, specifically divine voices in your head that tell you this is the fucking cat. He can totally speak French. Squeeze his right paw and he'll start doing code. Unless you have that, I would say give up the dream. give up the dream, because Carl can attest firsthand. He was one of the lucky ones to receive those messages. From me, Reb Maisel, from the Rebuttal Podcast, from my listeners, to Blackie the Talking Cat in the very vocal heaven he absolutely ended up in. Rest in peace, our lovely legal legacy. Goodbye, everybody. I will see you next time very, very soon. And thank you to Alyssa, my new editor of this podcast that has been a long time coming and that I cannot wait to show off to y'all with respect to her amazing work and prowess and ability to help me crank out these episodes way more, because networks are knocking, baby. Networks are knocking, and we got to get it together. Love you. Be safe. Bye.